Good morning, happy Thursday. Welcome to the Legal Tea. This is the Legal Tea with LT, where I attempt to spill on important legal issues in just the amount of time that it takes me to steep a cup of tea. I think asking a lawyer to explain something in 5 minutes or less is a very big challenge, but I'm getting better at it. I think I'm getting better at it. Okay, so we are in our estate planning series, and we are wrapping it up. Today is going to be the last day. We have talked about your will and why you need it, your financial power of attorney, your medical power of attorney, your HIPAA release, and your advance directive. And those are the basic 5 documents that everybody needs. Today, we're going to talk about what is a trust. Not everybody needs a trust, but I want to touch on it because I get a lot of clients that will either come to me and say, I think I need a revocable trust, or I think I need an irrevocable trust, and I'll talk them out of it. And then I'll have clients who don't even know what a trust is, but I'll say, hey, have you thought about this? So I want to kind of summarize really quickly what a trust is. We're going to talk about a couple of examples, but there are too many to talk about in 5 minutes. So as always, this is not ever meant to take the place of talking to your attorney. These videos are just meant to be educational. I want them to give you a baseline knowledge of these concepts so that when you do have a conversation with your attorney, you're starting from somewhere and not starting from not knowing anything. Okay, let's get started. So a trust is an entity, almost like a business. You can think of it like a little LLC. It's its own separate entity. It takes things out of your possession, out of your estate, and puts it into its own possession. So it becomes the owner of things. You have to have 3 roles in order to start a trust. So you have a grantor, a trustee, and a beneficiary. 3 roles, but you need at least 2 people. One person can have 2 of these roles, but you can't have one person that has all 3 roles. So you can have somebody that is the grantor and the beneficiary, but then they can't be the trustee. Or you can have someone that's the grantor and the trustee, but then they can't also be the beneficiary. A little complicated, but you'll get the gist of it as we go. The grantor is the one who starts off with the assets. You can put anything in trust: a house, money, your car, sky's the limit. But the grantor grants the trust access to these assets, okay? And then they also grant the trustee access to the assets. The trustee is someone that we trust to hold the assets for the benefit of the beneficiary. So those are our 3 roles. The grantor grants access to the assets. The trustee holds them because we decided they're trustworthy for the benefit of the beneficiary. That means that the trustee has to prove, I'm giving these assets, I'm giving this check every month to the beneficiary, and I'm distributing it the way that the grantor wants me to, because that's another thing about trust. The grantor can say, I want the beneficiary to get these assets for this reason during this time. Sky's the limit there as well. There is a lot of flexibility with trusts. Okay, so to kind of help break this down, we're going to talk about the number 1 type of trust that you put in your will. So there are a lot of different categories of trusts. So you'll have trusts that are called testamentary trust and then non-testamentary trust, revocable trust, and irrevocable trust. We are just going to talk about one type of trust today, a testamentary trust. It's called a testamentary trust because it's in your last will and testament. So it's a little paragraph. We put it in your last will and testament, so we call it a testamentary trust. The trust we're going to talk about today is a contingent trust. I'm fulfilling my law professor dreams. If you were one of my students in law school, you know I love writing on the whiteboard. Okay, contingent trust. Contingent trusts are used a lot of times for someone who's going to inherit from us who's 18 years or older. Or younger, sorry. There are other reasons for a contingent trust. We're just going to use this example this morning. Okay, so if you have little kiddos that are under the age of 18, you're going to want to include a contingent trust in your will because they can't inherit So what you do is you're the grantor. The trust isn't created until you pass away because it's included in your will, and you say, okay, after I pass away, I'm gonna grant access to all of these assets, whether it's my house, whether it's my car, it's usually just money. It could be money from a life insurance policy or a 401k. We're gonna grant access to that to the trustee. We're gonna put it in trust, give that trustee access for the benefit of my kids until they reach the age of 18 or until they're 25. Or we're gonna give 25% of it at 20, 25% of it at 25, and the other 50% at 30. You can do that too, kind of span it out over their lives. The trustee can be a person, it can be their grandparents, it can be a family friend, it can also be a bank, depending on how much money you have in trust. Banks will help hold money and distribute money to beneficiaries. Okay, so that is the quickest explanation of trust that I think I can give you. My tea is absolutely steeped by now, but if you have any questions, feel free to let me know. Keep them coming. Also, next month, again, we are going to talk about businesses. So I've already gotten a bunch of questions from y'all that you're interested in wanting answers, whether what's a non-compete or how do I protect my assets in a joint venture. DM me, let me know, and I will include those in our videos. Okay, well that is the Legal Tea on Trusts, the first of many episodes of Legal Tea on Trust. And I hope y'all all have a blessed Thursday and a wonderful weekend. We'll talk soon.